So welcome back to Federal Securities Laws. This is part 2. And let's begin with the 1934 Act. This was enacted by FDR during his administration. In large part, it was due to what was thought to be irresponsible financial practices that caused the 1929 crash of the stock market. What I will tell you is that prior to both the 1933 and the 1934 Acts, there was very little regulation of our stock market. The 1934 Act is the law that created the Securities Exchange Commission. So this Act, 1934 Act, applies to the secondary securities market. So after you've had that initial public offering, any shares that are listed on a national exchange or a company that has at least $10 million in worth and 500 shareholders is subject to this law. This law has some very significant anti-fraud provisions that always apply. So let's take a look at it. And for whatever reason, there you go, here we go. Requirements of the 1934 Act. The primary requirements of this Act include registration of securities that are listed on a national exchange. Also, there are certain disclosure requirements, and in the event that there's some sort of a proxy solicitation, margin, or perhaps they also, this Act also establishes both margin and audit requirements. The purpose of this Act is to ensure fairness and investor confidence. And so some of the requirements that you will see as part of this Act include a Form 10-K, and this form has to be filed annually by any firm subject to this Act. It is certified by a CPA. There's also another requirement under this Act, and that's a Form 10-Q, and that's filed quarterly. Certification by a CPA is not necessary for a Form 10-Q. And as I said, proxy solicitations are also subject to this Act. A proxy solicitation must be approved by the Securities Exchange Commission, and there must be a clear and concise statement of the issues that are to be voted on, and this must be sent to the shareholders. So let's look at the anti-fraud provisions of this Act. The anti-fraud provisions include both 10b and 10b-5. They must be complied with. Even if the security does not have to be registered, these must be complied with. And we'll talk a little bit about what they include in just a second. But what I will tell you is that the use of insider information is absolutely prohibited under this Act. And so who is an insider? A director, an officer, an accountant may be an insider. An attorney may be an insider. So the use of insider information is prohibited until, of course, it becomes public. So if you like to watch movies or you like to look for anti-fraud in movies, one thing that you could look at is if you ever watch The Big Chill. The character in The Big Chill, that's played by Kevin Kline, in one scene is jogging with William Hurt, another character in The Big Chill. And Kevin Kline tells William Hurt of his company, Running Dog. It's a sneaker company, and they're getting ready to go public and to purchase shares. This is a hot tip that was used in a movie. Of course, if this were real life, this would be prohibited. Perhaps you remember, perhaps you're not quite old enough to remember, but maybe you do. Martha Stewart was sent to prison. Camp Cupcake is what they refer to this federal prison as. And she was found guilty not of insider trading, but she was found guilty on all 4 counts of obstructing justice in terms of an investigation. She was being investigated for using a hot tip to trade stocks. She was friends with the CEO of a company, M-Clone, and Sam Waxel had received some bad news. That is that a drug that the company had been working on did not receive FDA approval. So he called Martha, and Martha traded her stock. She sold her shares in ImClone based on this inside information. So that's what although she was not in prison for inside information, this was the investigation that she was found to have obstructed. She spent several months in Camp Cupcake, something you would not want to do. So you can't use inside information to trade stock. So you wouldn't be able to use a hot tip to trade a stock. The anti-fraud provisions of 10b and 10b-5, fraud is virtually any untrue statement of material fact. Fraud can also include an omission. So if you leave out a statement that should be included, remember, for there to be fraud, there needs to be scienter or intent to deceive, but scienter can be satisfied by reckless disregard for the truth. So if you are convicted under 10b or 10b-5, there's a possibility not only of fines, but imprisonment as well. A little fun fact, if you want to look at the possible punishment, any person who violates these provisions is guilty of a crime and can be fined up to $5 million and imprisoned for up to 20 years. Corporate defendants can be fined up to $25 million. A little fun fact here is this punishment was significantly increased under Sarbanes-Oxley. The numbers used to be 1 million, 10 years, and 2.5 million. And so now it's 5 million, 20 years, and 25 million. Another source of law that you need to be familiar with includes blue sky laws. Blue sky laws are simply state laws, state securities laws that have to be complied with. The first state to recognize a problem was Kansas. And in 1911, Kansas adopted what is now referred to as blue sky laws. And the case that is the United States Supreme Court case that coined the term blue sky laws was Hall versus Geiger-Jones Company. And you'll see the quote there at the bottom of included in this slide. So Sarbanes-Oxley was passed in 2002. Largely, this was in response to the Enron debacle, where $60 billion in shareholder wealth was lost, and in addition, the WorldCom loss of $175 billion in shareholder loss was another incentive to pass something like Sarbanes-Oxley. Sarbanes-Oxley does a lot of things, but let me point out a couple of major things that they do. Section 906, CFOs and CEOs have to certify financial reports under Sarbanes-Oxley. If you do not, then you may be fined $1 million and serve up to 10 years in prison. For willful violations of Section 906, there could be $5 million in fines and up to 20 years in prison. So there are significant incentives for CFOs and CEOs to comply with Sarbanes-Oxley. Section 302 of Sarbanes-Oxley, officers are responsible for maintaining effective internal controls, and it also requires disclosure of all significant changes, all significant internal control deficiencies to both the auditor and to the audit committee as well. So let's look at some of the questions that I assigned you for these modules. And the first question is question 15, and it deals with exempt transactions. And so with this question, 15, Regulation D provides for important exemptions to registration of securities under the Securities Act of 1933. Which of the following would be exempt? And so, 1, issuance of $500,000 of securities sold in a 12-month period to 40 investors. And then 2, issuance of $2 million of securities sold in a 12-month period to 10 investors. The issuer restricts the right of the purchasers to resell for 2 years. And so the answer to this is C. Both 1 and 2 would be exempt. So Section 504 exempts transactions up to $1 million within 12-month period. So number 1 would be exempt. And then number 2 is exempt because of Section 505, $5 million in 12 months to up to 35 unaccredited investors and any number of accredited investors. So this number 2 qualifies under Section 505. So your answer is C, both 1 and 2. So let's look at the next one. So just to kind of refresh your memory, Rule 506 has an exemption for the private placement of an unlimited amount of securities. Accredited investors and up to 35 sophisticated unaccredited investors would be allowed. So 17, Eldridge Corporation is seeking to offer $7 million of securities under Regulation D of the Securities Act of 1933. Which of the following is or are true if Eldridge wants an exemption from registration under the Securities Act of 1933? 1, Eldridge must comply with Rule 506 of Regulation D, and the answer is yes. 2, these securities could be debentures, and that's true. And 3, these securities could be investment contracts, and that's true also. So your answer to this one would be D. Let's go on and look at a question involving a casual sale exemption. So 19, which of the following facts will result in an offering of securities being exempt from registration under the Securities Act of 1933? And so your answer here is C. The sale or offer to sell the securities is made by a person other than an issuer, underwriter, or dealer. So that would be your answer to this as a casual sale exemption. Question 21, Regulation D, Section 505 exemption. So Fry, Inc. intends to make $2 million common stock offering under Rule 505 of Regulation D of the Securities Act of 1933. Fry, and your answer is C, must notify the Securities Exchange Commission within 15 days of the after the first sale of the offering. So this is your answer. Well, let's look and see why the others wouldn't be your answers. So A, may sell the stock to an unlimited number of investors, and the answer is no, you may only sell up to 35 unaccredited investors under this exemption. And then how about B? Why wouldn't it be B? May make the offering through a general advertisement, and that would not be allowed. And then D, must provide all investors with a prospectus. And that's not true. Accredited investors need not receive any formal information. So that's why that would not be your answer. So your answer here is C, must notify the Securities Exchange Commission within 15 days. What about an intrastate exemption? So which of the following statements concerning an initial intrastate securities offering made by an issuer residing in and doing business in that state is correct? And your answer here is the offering would be exempt from the registration requirements of the 1933 Act. Offering statement. So which of the following transactions will be exempt from the full-blown registration requirements of the Securities Act of 1933? And the answer is B, all offerings made under Regulation A. So A is not your answer because all intrastate offerings are not exempt. C also is not your answer because So C says any resale of a security purchased under a Regulation D offering. Under Regulation D, the securities can't be resold for 2 years. And then D is not your answer either, because there's no such exemption, any stockbroker transaction. And so the answer here to this question is B, and only B. So what is the purpose of 10b-5? So let's, by the way, I almost always ask this one on the test, so be sure that you know this one. All right, so the Securities Exchange Commission promulgated Rule 10b-5 under Section 10b of the Securities Exchange Act of 1934. Which of the following is or are the purposes of this act? All right, so let's look at the first one. To rate securities so investors can choose more wisely. No, the Securities Exchange Commission does not do that. Second one, to encourage disclosure of information relevant to investors. Yes. Third column here, to deter fraud involving securities. The answer is yes. And so your answer here is B. So no, yes, yes. Let's look at 2 more questions, question 30 and question 32. 30, which of the following factors by itself requires a corporation to comply with the reporting requirements of the Securities Exchange Act of 1934? And the answer is B. If you have shares listed on a national securities exchange. I usually ask that question too. And then 32, under the Securities Act of 1933, which of the following statements is correct concerning a public issuer of securities who has made a registered offering? And your answer is C. The issuer must file an annual report, a Form 10-K, with the Securities Exchange Commission. You also need to know that. And then question 34, the Securities Exchange Commission promulgated Rule 10b-5 from power it was given the Securities Exchange Act under the Securities Exchange Act of 1934. Under this rule, it is unlawful for any person to use a scheme to defraud another in connection with the purchase of any security? Yes. The sale of any security? The answer is yes also. And your answer would be A. Again, know this one for the test as well. All right, so let's look at questions 36 and 37. Link Corporation is subject to the reporting provisions of the Securities Exchange Act of 1934. Question 36. Which of the following situations would require Link to be subject to the reporting provisions of the 1934 Act? First, shares listed on a national securities exchange? Yes. More than one class of stock? No. So your answer is B. Number 37, which of the following documents must Link file with the Securities Exchange Commission? Quarterly reports, Form 10-Qs, and if there are any proxy statements, yes. And so the answer is yes, and your answer would be A. And then one more Sarbanes-Oxley question, 43. Under the Sarbanes-Oxley Act, which of the following officers must periodically certify that reports comply fully with relevant securities laws and also fairly represent the financial condition of the company in all material respects? And please don't get this one wrong. The answer is C, the CFO and the CEO. And so that is it for the basic knowledge that you need to pass not only this next test, but to be successful on this part of the CPA exam. And so thank you so much. The next module you will be reading is Module 25, and take care.